today to participate in our discussion. I've been looking forward to it. I understand we have a broad range of people and job titles on the call today, and our discussion is designed to provide something of interest and use for everyone. In doing these discussions with other large organizations like yourselves, there are frequently many, many questions that you may have already or that may come up in the course of the presentation. And so our design here is that we have sort of a 60-minute presentation of sort of the lay of the land with open source software, and then we want to allow plenty of time to potentially respond to questions. Unlike other presentations I've done, which usually focus on issues seen from either the perspective of the recipient or customer of technology alone, or potentially from the vendor, the perspective of the vendor or provider of technology alone, this discussion will focus on both perspectives, talk about unique risks associated with both, and also how we might mitigate those risks. Open source software is a tremendous technology tool available to every business. I venture to say no business today, whether large or small, whether traditional or technology-oriented, can avoid the use of open source software. Rather, at this very moment, I would suggest every business of every size is using potentially dozens, if not hundreds, of open source applications, frequently without knowing they're doing so. So what is our goal today? To provide that foundation I mentioned or overview for understanding open source better, the risks that it presents, and methods for mitigating that risk, while still, of course, gaining the tremendous benefits of open source software. We'll begin by setting the agenda for our discussion and then move to the meat of the presentation. At a very high level overview, the presentation will be divided into three parts. First, some background, just to make sure all of us are on the same footing. Second of all, the overall challenges of open source software. And please understand, I am in no way a critic of open source software. I think it's tremendously useful. I actually represent a number of companies whose sole products are open source, as well as working with large organizations that deploy open source all the time. Our discussion is about how do we address use a bit better. And finally, the third part of our presentation will focus on controlling risks. And again, I emphasize, and we'll have separate portions for each, controlling risk from the vendor-provider perspective as well as the customer-recipient perspective. With those words, we'll turn to our agenda. And one more thing, we're going to be giving you an MCLE code at some point during the presentation for you to enter. Please make sure to listen for that code, and of course we'll take plenty of time to give you an opportunity to enter that code. All right, so let's take a look at our agenda. First of all, the two perspectives, and this is exactly what I was talking about a moment ago, which is the perspective of either the customer or sort of recipient of open source software, and then the perspective of those who are redistributing the open source. They themselves are vendors or distributors of open source software, either alone or generally in combination with some proprietary software or other application they're making available. We'll spend just a moment on nomenclature, talk about some key terms that are relevant for understanding open source. We'll talk just a moment about where open source actually came from, the mythical story about Richard Stallman. We'll talk about the types of licenses and the trends that we are seeing in open source licensing. And specifically what I'm talking about there is the movement away from a viral license as the most popular form of open source software licensing on the face of the earth to something far less viral. And clearly this is driven by businesses like yourselves wanting to have a bit more control and protection of their own proprietary intellectual property. So we'll talk about that. We'll also talk about some changes in open source licenses, particularly General Public License V2 or 2.2 to version 3. We'll talk about how it's impossible to avoid open source these days, and that goes back to my introductory comment about it is almost impossible to find a business today, certainly not a business of your size, that isn't using open source in a very profound way. Of course, there are many benefits to open source. We'll touch on that for just a moment, and then we'll talk about challenges and risks. And we'll group this, if you will, first from a vendor perspective. That is, you're distributing open source with some product of yours. We'll talk about how to document risk, and that's the use of questionnaires by your developers, et cetera, that many people are using. And then we'll talk about vendor engagements, meaning that you are the recipient of open source software because you are purchasing some product or service from a third-party vendor, and how you might control risk there. So that's our agenda today. Lots of topics for us to talk about. Moving on to two perspectives, and just to be clear, because this is a point we'll return to repeatedly, in fact, this will be the third time in this presentation thus far in the first 6 minutes, that we've got the perspective of the customer-consumer of open source. You have nothing to do with distributing. It's all about you're going to go out and, for example, buy IBM's product WebSphere, for example. And if you have purchased that product or licensed that product, you know that as you install WebSphere, you're going to be presented with a licensed TXT file on the install media or download. And at last count, IBM had about 233 pages of open source that are embedded in its proprietary software. And so this is a situation where you as the customer of open source will be receiving open source software, generally, but not always, in the form of open source integrated into some commercial product you're buying. You're going to spend $5 million for a ERP system, and it may have open source embedded in it. How do you control risk in those situations? Of course, it may be a situation where you are licensing open source directly, say Red Hat, for example, or a version of Linux from HP, that sort of thing. And again, we'll talk a little bit about how to control risk in those situations. Next, we'll talk about the perspective of distributor-vendor. That is, you are the original developer of, say, a piece of open source that you're distributing to others. But more likely, you are distributing open source as part of your own technology products. It might be proprietary software. It might be embedded in a piece of hardware or a chip, that kind of thing. So those are the two perspectives. A moment about nomenclature, and I realize that we have a number of tech folks on the phone, and so please forgive us for just a second. We want to just lay the foundation. Source code, a key term in looking at open source, meaning that you are given the actual programming that a skilled programmer can understand and can, more importantly, modify, correct bugs, etc. The source code is the trade secrets that comprise the software. It has the trade secrets in them, whereas object code is machine readable only. It would be unintelligible by you or me, but it can be understood by a computer and executed. So source code, a skilled programmer can easily read it, although it may not look like something that is understandable to the average person. And object code, which truly is not understandable to anyone. Libraries. This is a key term, particularly in the lesser library, general public license, and the general public license. A programming library or function is something that sort of stands alone, that other software, which generally is proprietary, may call to that library, send information to the library for processing, or request that that library provide certain functionality. For example, draw a square on the screen, something very, very simple. And you use that square all the time, and you may want to not have to write the code to draw a square of various sizes on a screen. You can get a graphics library that allows you to do that. A lot of times these libraries are for mathematical functions, taking the square root of something, multiplying two numbers in an efficient manner, dividing two numbers in a fast and efficient manner, that sort of thing. A library is generally thought of as separate and apart from the underlying code. And therefore, there is a specific license, the LGPL, that governs the use of such libraries. And we'll talk about that in more detail in a moment. Next, we have the exotic concept of linking, static and dynamic linking. And why is this important? Because with regard to the general public license and some others, the way that you link proprietary software, that is your own intellectual property, with open source software may determine in its entirety whether or not your proprietary software is infected, if you will, with the open source virus, meaning that if you were to distribute that to a third party, that you may be required to provide the source code to your own proprietary software, to license it without fee, and to make it available under an open source license. And again, more detail on all of this later. But static linking it essentially refers to a single compiled file, which is then distributed, that it can be executed on a computer, generally of an end customer. And so you essentially have taken all the bits and pieces, your proprietary software, other people's proprietary software, and potentially some open source. You have combined it all into a file which can be executed readily on a computer, and then you distribute it. Whereas dynamic linking means that you distribute independent files to the end customer or the recipient, and in executing the software, they will combine on the fly, if you will, dynamically to compose the overall application that's needed to operate on that end customer system. So static dynamic linking. Static linking is the type of linking which frequently will cause problems under the general public license and will infect the underlying proprietary code that's combined. Whereas dynamic linking, at least there is a strong argument that there is no situation where you will see the underlying proprietary code infected. More on all of this in a bit. One final term, which is not on this list and should be, is the term orphan code. And if you're not familiar with this concept, it has come up quite a bit. In fact, it's been the subject of a lawsuit that we'll talk about in just a bit. Orphan code can refer to any software, but frequently it refers to open source software, which is no longer actively supported. Generally, you have definitions of orphan code as code which is no longer actively supported or has been designated end of life by a developer. More likely in the open source community, it means that it's a piece of open source which has not been contributed to, has not been modified. No bug fixes have been provided in the preceding 12 months. Why are we worried about orphan code? Well, in the security industry, security professionals have identified orphan code as one of the top 2 or 3 ways that hackers have exploited in gaining access to and exploiting flaws in software. And so everyone's concerned about the use of orphan code. And in fact, these days it's not uncommon to include orphan code warranties in agreements where you are licensing software from third parties, that they are giving you only actively maintained code. And although we have some examples of specific contract language that we'll be touching on in this presentation today, I did not include an orphan code warranty. If you like, we'd be very pleased to send you an example. It's one we use all the time, and you might find it of use. So generally, when you are the recipient of open source, the customer of proprietary software that includes open source, you would normally include an orphan code provision. If you, on the other hand, are a distributor of open source, whether standalone or in combination with one of your own products, you may be asked to give an orphan code warranty to one of your end customers. So we want to make sure to touch on that. So how did we get here today? 1983, it's a sunny day. Richard Stallman is in his office trying to print a document, and as likely many of you have encountered, The printer jammed. And this is particularly true way back when they used Z-fold or fan-fold paper, and it was prone to jam about every 3 or 4 pages. Mr. Stallman said to himself, gosh, I could probably fix that by patching the software that runs the printer. And so he contacted Xerox and said, hey, would you mind if I got a hold of your source code so I could fix this? We'll make it available to everybody. It'll be a benefit to everyone, including you. Xerox, quite understandably, said, well, the source code is our very valuable trade secret. We really can't release it. And from this story, that I believe to be true, Mr. Stallman set about to create the open source movement. He is the one that drafted the sort of first license. He's the one that was really a driving force. His baby is the general public license. He is an absolute advocate of open source software. He believes that software should be always furnished in source code form, and that everyone should have the ability to contribute to that software, improve it, so that in the end we have a better product for everyone. So that was the purported start of open source software. One of the problems, though, is that this all started with a view to sort of a community sharing of information with developers. And what has happened is that open source has become wildly popular and now is deployed by many very large and sophisticated organizations. Yet we don't necessarily have the proper discipline around this and potentially the licenses necessary to really exploit this in a commercial environment. And we'll touch on this in just a minute. We're seeing a bit of a trend away from the use of viral licenses. So what is open source? Just a little more background. Software that's distributed in source code form under a license that will not require the payment of any license fees, although software support or maintenance or customization, which is how Red Hat, now IBM, makes their money, can certainly be charged, but generally no license fee, source code available and made available under a known open source license, of which there are hundreds. There are, however, some primary license, like the general public license, Apache v2, the Mozilla license, etc. And again, we'll talk a little more specifically about that in a moment. Where do you get open source? Generally, you might of course get it from an actual developer, but most likely you're going to get open source through, if you're licensing open source directly, through an open source online project like SourceForge, where hundreds if not thousands of open source applications are made available, and where people are invited all over the world to modify those applications and hopefully make them better, to provide comments on those applications, etc. So it does take a village to create open source in general. It is certainly the case that a number of open source applications are created by a single individual or group of individuals and then made available to others. But in most instances, a piece of open source has contributions from people potentially all over the world. One person will create an application or group of people, and then they will post it online, for example, on SourceForge, and then they will invite others to contribute. Those contributors can be anywhere, which means, and we'll touch on this in more detail in a moment, a lot of different laws regarding intellectual property rights can apply. Contributors may and likely do work for others. And so what does that mean if they are engaged by a company who has, as most do, agreements with those employees that the employer owns the intellectual property they create while at work? So if an employee modifies a piece of open source at work and then on their own sort of decision, they upload that fix to an open source community, did they really have the right to do that? Almost certainly not, unless their employer has specifically authorized the upload. So you can see it becomes incredibly difficult to have confidence in the pedigree of a piece of open source, particularly if more than a handful of people have contributed to it. Was the contribution made according to applicable law in the jurisdiction in which the upload was made? Did the person actually have the rights to upload it in the first place? did in fact somebody else own it, and that they had no such right. And we'll expand on this in a moment, but let's turn to this graph or pie chart showing the popularity of open source all over the world. Let me give a little background here. Black Duck, as many of you might be aware, is one of the leading consulting companies involving open source software. And one of their primary products or services is to come in and do a check of an application, generally a commercial application that is about to be made available to others. And they will check that application to see if there is any open source present. More particularly, they will check that application to see if there is any viral open source which is present. A lot of times people will use Black Duck to do assessments in the context of a merger or acquisition to ensure that the technology of the company being acquired is clear of any viral licenses, or if viral licenses were used, how were they used, to get better comfort that the assets that they're buying, in fact, are not subject to an open source license. What's very interesting about the graph that you see in front of you, and so, by the way, Black Duck makes a survey because they have an incredible amount of information about how much open source is being used in the world today. And every year or so, they make a chart available like this one, which shows overall, worldwide, how open source is being used by license. The trend that's interesting is that up until relatively recently, the largest or most popular open source license was clearly the GNU, General Public License v2. No question about it, which is a highly viral license. What we're now seeing, though, is that in its place, the MIT license, which is essentially 3 or so paragraphs, very simple, non-viral, very straightforward license, is now becoming the most popular. Why? Because we're seeing more commercial enterprises using open source, and they want to have better control over how open source is used. Also, take a look at the third most popular license on the face of the earth, the Apache License v2. And we encounter this license almost on a daily basis. It is also non-viral. Unless you intentionally dedicate something to the Apache license, you're not going to have it infect the software. So take a look at the 3 most popular licenses, which account for nearly 2/3 of all use of open source in the world today, and you'll see that the overwhelming majority are governed by non-viral licenses today, and the rest being the GNU, General Public License. I'll quickly mention to you, if I fail to do this at the top, that you have the ability to enter questions into the Q&A box that should be at the bottom of your screen, and we will absolutely hit those either in the course of the presentation or directly after we sort of finish the sort of formal part of this. So let's talk a little bit more about licenses. You'll see that the 4th license in line here is the GNU General Public License v3. So that's the current version of the GPL. You'll note that at least twice, if not more, uses of GPL-governed software are in fact subject to the older version of the General Public License, which is the v2. So the GPL v3, even though it's been out several years now, has not gained the popularity of v2. Let me quickly point out a couple of differences between version 2 of the General Public License and version 3. First of all, version 2 did not have the input of, the level of input that v3 has had from industry, from real users in the commercial context of open source software, and of multiple lawyers. We actually provided commentary for consideration, the construction of the version 3 of the GPL. One big thing that v3 fixed over v2 was the following. Under version 2 of the GPL, it is not in fact clear, and in fact some people argue it's quite clear, and is the question of, if I make available a cloud service and I use a piece of GPL v2 software in my cloud application, is that a distribution that would trigger the open source virus I mentioned? Is that a distribution to third parties, or since we're hosting it all in our own servers, is in fact a distribution? Many people argue it's absolutely not, but there is a lack of clarity. Some people argue that it is a distribution and that the entire cloud application must be distributed. It's one of the reasons why Google is so concerned about this in certain of its cloud applications. Version 3 makes very clear that, in fact, that is not a distribution. In fact, version 3, when it was created, was issued along with a sister license. And that sister license, which is very uncommon, we see it very seldom, is the Affero General Public License. And what is the difference between the GPL v3 and the Affero General Public License? Essentially one thing. GPL v3 says if you're working in a cloud environment, that is not a distribution. The Affero license says it's absolutely positively a distribution. So if you are a cloud provider and you see an Affero license come in, you would generally want to be very concerned about how the software is being used. Another point that was clarified between v2 and v3 is the one that comes up all the time. Suppose I, as a large company like yours, needs to use subcontractors, outsource vendors, others in helping us create our products. If we hand them a piece of our proprietary software which has been combined with a viral license, is that a distribution requiring our proprietary software to be subject to an open source license, to be distributed without license fee, and requiring us to disclose our source code? V2, ambiguous. V3, much clearer now that that in fact is not a distribution triggering the virus. So you'll note here there are lots of other licenses. In fact, we frequently see very obscure types of licenses. But if you look at the majority, MIT, a one-page, very simple, non-viral license, is now taking a much larger role. V2, a now outdated version of the GPL license, remains a player. And we have Apache V2, another non-viral license, taking up the rest of sort of the majority there. So it's a very interesting statistic to see. As I mentioned, it's impossible to avoid open source software. It's found in almost every commercial application. In fact, interoperability, if you're using SSL, for example, you've got to use open source. So there are lots of open source out there that just simply cannot be avoided. If you do federal contracting, which you do, there's this press to have a certain portion of proprietary software being provided in open source form. So it's just another driver for the popularity of open source. Benefits of open source, just briefly. Of course, most people, when they talk about open source, the very first thing they mention is it's free. And of course, is it truly free? For example, Linux. That's absolutely free, but if you want a version of it certified by Red Hat or HP, you're absolutely going to be paying fees for it. Plus there is maintenance support. Plus there is potentially customization costs. So free, yes, but not necessarily free in its entirety. You do have access to source code, meaning that you don't have to rely on the vendor. You can make your own potential revisions. You don't have to rely on a single point of contact or failure, if you will. If you're going to create something and rely on a piece of software, and you have the choice between a small vendor that could potentially go bankrupt providing proprietary software for which there is no source code available, or an open source equivalent, frequently businesses are now choosing the open source equivalent because it gives them greater control. There's this many eyes theory as to making open source more reliable than proprietary software. So what is that if you're not familiar? It's a point we'll touch on several times, but essentially it's this. If you have a piece of software that's developed in proprietary fashion by a single developer, then you have only that developer's personnel who have looked at the source code to determine whether it's bug-free, that it's secure, that it is going to work according to its specifications. And so you have a limited set of people taking a look at it. The argument is that if you have a piece of open source software, and Linux is a great example where you have thousands and thousands of people looking at the source code, the argument is that those people will help find bugs far more quickly and security vulnerabilities than, say, a proprietary vendor. This many-eyes theory only works, though, if you have a popular open source project. And believe it or not, we have many very large multinational clients that will use open source where basically somebody in Thailand, an individual, wrote the software and 2 other people have contributed to it, and that's the extent of it. So many eyes there? No. And this is one of the common problems, and we'll touch on this talking about vendor-oriented issues, which is relying a bit too heavily on the concept of, well, lots of others have looked at this, so the software must be secure, must be reliable. There's also organic growth, meaning that if you have a popular piece of open source and lots of people are interested in it, then lots of people are going to be contributing to it and making it a better product. If, on the other hand, you don't have a popular product, you're not going to have those contributions, and it's going to wither on the vine. And so it's sort of a self-policing, if you will, environment where if you've got something that's good, it's going to stay good. If you have something that's not worthwhile, it's going to die. Let's talk about some of the challenges. And certainly the very first one that most people focus on, there are 2 that are truly major considerations when you're talking about open source licenses, is that there is the concept of viral versus non-viral, and we've talked about that, and there are many gray areas as to whether or not you have a piece of software, a piece of proprietary software that's combined with open source, and whether or not that's created a situation where the proprietary software has been infected. And in fact, we'll give some very specific examples of that in a moment. That is the gray area problem. So viral versus viral, key issue or major issue number 1. The other major issue is no standard contractual protections. You are on your own. And sometimes this is difficult to really appreciate, that you don't have an IP indemnity. You don't have standard warranties. Frequently, you don't have anyone to call for support. The original licensor may or may not respond to your calls for help or emails. This may be fine if you have 300 lines of code and you have very sophisticated developers as part of your personnel, because they can understand the code, they can potentially support it themselves, get comfortable that it's reliable, etc. You start to have open source, which is tens of thousands of lines of code, and that becomes quite difficult. It takes a long time to get powered up and familiar with a piece of code like that. So generally, when we're talking about this, we always talk in terms of understand the viral possibilities, check the licenses to understand whether or not it's viral or non-viral, and then understand that no matter what, you're generally going to be on your own if something goes wrong. And your sole and exclusive remedy if something goes wrong is to absorb the impact of whatever that might be and potentially find some piece of replacement software. We always talk about this in the context of if you're going to be using open source either as a consumer of open source or as a vendor with products with open source in them, that if you have a key application which includes open source which may fail, then obviously it's a risk assessment issue as to whether or not you're comfortable relying on a piece of software written by third parties whose pedigree is uncertain, operating in the environment. We'll talk about ways to mitigate that risk a bit, but nonetheless it is a concern. Other challenges. Open source licenses have not been fully tested by the courts, notwithstanding the fact, if you remember, that this all started in 1983, quite some time ago. If you look at all open source licenses in the world, litigation in the world today, there really isn't much, maybe a couple of dozen. And yes, there are cases periodically that say do we have an enforceable license or not? Yes. The question is, are the viral aspects or other aspects of the open source license enforceable? Those have not necessarily been litigated. In fact, the viral context issue has really not been litigated thoroughly. Germany has had a number of these litigations, but overall it's been really a very limited amount. You may be familiar with the SCO litigation that occurred involving Linux and some shakedown letters that were sent out over Linux, and that entire thing essentially fizzled. Many open source licenses were written years ago. They're quite simple and may have been made without any legal input, which is why a lot of people have worked on Apache v2 and also GPL v3. Open source licenses have holes in them. Now, what is this about? If you look at some licenses, for example, the limitation of liability, GPL v2 as an example, isn't necessarily bulletproof, which is why people frequently will use other language to fill the holes. Let me be specific, and then a little later on in the presentation we'll show you example contract language to address this. But the limitation of liability in the GPL license is focused on essentially use, that is disclaiming liability if the software has a bug in it, something like that. But it doesn't necessarily disclaim liability for distribution. So if you were to include GPL v2 software in a product, redistributed to others, and it causes a problem, you may not be able to sue the original licensor for a operational problem. But there may be liability for simply distribution. And my point simply is that, again, some of these licenses have not been drafted with the clearest legal terms, which is why a lot of sophisticated organizations will distribute open source with additional terms wrapped around them to protect, in particular, against liability. So, as I mentioned, it is very confusing as to what is and is not a derivative work and what does and does not constitute a distribution. Derivative works, why is that important? Because when you modify, in particular, GPL-governed code and create a derivative work and then distribute that derivative work to others, you will have potentially a viral aspect. There is much confusion around what in the open source community about where we have derivative works, when we have derivative works, and when we have distributions. Even the Software Freedom Law Center, created as the legal arm of the Free Software Foundation, has not been clear on this. In fact, if we look at one of the oldest and most knowledgeable business people in this area that are involved in open source since the outset, his quote is, "There are no definitive answers as to what constitutes a derivative work." So we have lots of concerns in this area and lots of ambiguity. As I mentioned, there's the problem of unknown pedigree. While not perfect, if you've got a commercial developer, generally they're very careful about how they develop their intellectual property in-house. They make sure they have a clean development environment, and they want to make sure that they don't introduce third-party intellectual property into that environment unless they do that in a very careful manner. Whereas in the community development process of open source, there really is no process for clean development. There is no due diligence that the software fix that was just uploaded from a teen in the Philippines sitting in a coffee house, if they copied that from somewhere else, if they read an article which had somebody's intellectual property in it and simply coded it up, there's no clarity as to whether or not that person has the rights. And then, as I mentioned, there's the problem of what about employees who have assigned their IP rights and what they create to others, creating open source changes or open source itself at work and then uploading it? It's unclear. Unless they are uploading and making those contributions without their employer's consent or with their employer's consent, there's a problem. In some instances, development communities for open source don't even include some click-through terms for the individual developers who are making the contributions. SourceForge does. Unknown pedigree, as I just mentioned, we just don't know if individual contributors can in fact make these contributions. And the most common method for getting open source is these foundries like SourceForge. They're a bit more careful, but again, they have no way of actually knowing. So if you have a piece of open source that is in any way popular, I would suggest it is impossible to know who owns the intellectual property rights in that application and whether or not it is in fact possible to use it as licensed under the relevant open source license. It just can't be done, which is why there's a bit of a leap of faith every time you use any kind of open source software. The good news is that we don't see much litigation in this area. As I mentioned, the other open source risks, no standard warranties. Doesn't have to work in accordance with any documentation, doesn't have to be virus-free, no indemnity for intellectual property infringement, and redistribution may require, as a result of the open source virus, disclosure of your own source code to proprietary programming. There is the potential liability, and this is what I mentioned as far as holes, places where the underlying open source license isn't effective in disclaiming all liability, for example. The language used in open source licenses, particularly licenses written long ago like the GPL v2, is at best confusing, and at worst, it's the subject of considerable dispute as to what it really means. I gave you a quote that distribution and derivative works. No one can seem to reach agreement on what that means. And again, we have little guidance from courts in this area. Security considerations. Security implications are frequently overlooked in the use of open source software. There is this false sense of security because you've got the source code, and there's this idea of the many eyes theory that everyone has looked at this and therefore it should be secure. Again, if you have a relatively straightforward piece of open source, it may be possible to actually vet it yourselves. But if it's complex, this might be quite a task. What we see are a lot of sophisticated companies who are very careful about bringing software into their organizations, but not necessarily looking into the true security or potentially lack thereof in open source software, particularly complex open source software being brought into the company. Are there viruses? Could there be backdoors? Could there be other security flaws? And as I mentioned, one of the things that we worry about now is orphan software. And it was actually the subject of a lawsuit between Massachusetts and Equifax, failure to patch using the most updated versions of the software. Intellectual property ownership. Once again, just to finally close the loop on this, we have the open source virus that I mentioned. And so what does this mean when you bring open source into a company, in particular if you are redistributing products to others that will include that open source? You want to isolate that development environment. You want to make sure senior management is approved prior to incorporation of open source into a commercial product that's going to be distributed. And this will lead us to the discussion we'll have in just a moment. You need to limit access to the source code to only those with a need to know. Why? Because having used to be a vendor, or rather a developer myself, worked in the defense industry for a very long time before going to law school, developers love to pick and choose. In other words, they'll hear that someone sitting next to them has a piece of source code that allows them to do the following 3 wonderful things. I'll keep that in mind, and a year later I might want that in order to do something in my own application. That kind of shifting of knowledge is great, except that that person that was sitting next to me who was using that source code may have been authorized to do it for a very limited purpose, and certainly not in the context of a commercial product. What frequently happens is that another developer will cannibalize a piece of that open source, or maybe everything, and put it into a commercial product without somebody clearly signing off. And so this leads us to sort of the next part of our conversation, which is mitigating risk or addressing risk in distributor vendors of open source software. So this is where you are yourself providing products to others that may contain open source. First, keeping the development environment clean. What does that mean? And that means documenting carefully when open source is being brought into the organization, making sure that a choice is made if it's being brought into a development environment for internal applications versus a development environment involved in creating products that will be distributed to third parties. If it's purely for internal use, then there could be a much more straightforward sign-off. On the other hand, if you are bringing something into the company that will be part of a development environment where products will be provided to third parties, far more scrutiny will be needed. Conduct periodic audits, and this can be as simple as going through and looking at questionnaires that we'll be talking about in a moment and making sure that all uses are in conformance with the responses provided to that questionnaire. It may also involve running periodic black duck or other types of audits by a third party to make sure that open source hasn't somehow crept into a commercial product. Hold development personnel accountable. A lot of companies now are requiring the individual developers who want to champion bringing in a piece of open source to fill out a form that makes clear they understand how the open source needs to be used, gets it identified, and that they sign off that they're going to ensure it's going to be used in that way and in no other way. If you haven't seen such a type of form, please let me know. I'll be pleased to send you an example of one that another company of about your size is currently using that we just put together for them. Fulfilling open source license obligations. Remarkably, this is an area where we see litigation. You may be familiar, there was a case not long ago where it really was unfortunate. What generally happens, and most of the litigation we see involving open source, essentially all arises from the following scenario. A company decides to use open source in a product. They distribute that product. They don't comply with the requirements of the relevant open source licenses as to how to give notice to the end customer of the presence of that open source. Letting them know what open source is present, what license applies, where they can get the source code for the software. Those are essentially the three basic things that need to be done. Companies will not comply with those requirements, or they'll try to skate on them by doing something similar but not really fulfilling those obligations. They'll get a letter from the Free Software Foundation or the legal arm of the Free Software Foundation saying, hey, you're not in compliance, please fix that up. And most folks will do that. Most companies will take a look and see all they need to do is update, say, their website to provide the information that's missing. But we do have a number of companies that simply say, no, we're not going to do that. And they end up getting sued, and as happened just recently, the lawsuit lasted about 20 minutes and was later dismissed due to agreement of the parties that the defendant would in fact comply. So why is it so hard to comply with open source license obligations? Well, generally it's not, but if you are using GPL or LGPL governed software, there are some specific requirements as to notice, including how long you need to make the source code available. The Free Software Foundation has actually made available a little pamphlet to help licensees understand their obligations as to how to provide notice for how long, etc. There should never be a reason why an organization would run afoul of these requirements. There is, however, a sliding scale and always discussion as to, what do we need to do to actually give notice? Do we need to include that in the base contract that we're providing to an end customer? Generally not, because you're constantly changing the composition of your software and updates and bug fixes, and you may include new open source. So people generally, the industry standard is that you'll have a URL that will take the customer to the website where there's a listing of the current open source software. And during that listing, we'll provide the name of by application. It will be, here is our XYZ product, and it contains the following 5 open source applications. It'll identify the applicable open source license, and then finally provide a hyperlink to the location where you originally gained access to the source code, normally SourceForge or some other development network like that. Generally, that's sufficient, and that's what most companies are doing to satisfy the requirements, and it gives them the flexibility to change the composition of their products at will. Let's talk a little bit more about documenting risk. Most companies today, when open source is brought into a development environment, they will have a questionnaire that needs to be filled out by the relevant developers. What is being licensed? How will that software be used? That is the open source. Will the software be modified? Will we distribute the software to others as part of a product of ours? Will our use change over time? And that last one is one that is the fall down point a lot of times, where you'll get authorization or approval to bring open source into an organization for the following purpose, and then that purpose will morph over time into something that legal never anticipated, and which could create additional risk to the organization. Let me stop on an example, though, that frequently goes missed by particularly larger organizations, particularly large organizations that have deep pockets. And that is the following. We have a developer who has brought in open source, and we're using it potentially entirely within our organization. We're never going to distribute it to others. Well, that sounds like a pretty low-risk application. Consider that example a little further, though. One day the developer notices a bug, and it's a pretty easy fix. And so they go in and they code up the bug and they fix that, and they dutifully go to their management and say, would you mind if I upload this fix to the open source community? Because that's what it's all about. That's how open source works. And I do understand, though, that my coding is essentially owned by the company, but would you mind if I uploaded it so others can benefit from this bug fix? Company says no problem. Now we have the possible scenario, which is someone downloads that application with the bug fix, something goes wrong, they do a little discovery and find out that a very large entity made the contribution that's causing the problem, and they go after you directly. So, do you have protection? Well, as I mentioned, most open source licenses do have disclaimers of liability, but as I further mentioned, some open source licenses have holes in their liability disclaimers. And so is it possible that you're putting the company at risk by making a contribution? Yes. Is that risk relatively low? Yes, it is. There's been little in the way of litigation. But does it create risk? Yes. Is it one you should understand? Absolutely. And so it's something to educate developers about that, you know, as they are making contributions, they may want to consider. For example, a large company that we work with will only have their developers make the contributions through anonymous accounts, not linked to the company, so that they can't be traced back. Not that they're doing anything wrong, but they want to be good people, provide those bug fixes to others, but if something goes wrong with them, they don't want to be responsible. Just a possibility. Documenting risk, that is these questionnaires, will help get better control over open source use. And we do recommend the use of a questionnaire, and again, happy to provide examples of those that we've developed for others. As I mentioned, Black Duck is frequently used as a backstop to do checks before a commercial product is actually sent out. Be wary, though, that products like or services like those of Black Duck can be over-inclusive. Be careful, in other words, what you're pointing the service at. All too often, we will have a client call us up in a panic because they have a report from Black Duck that's 1.5 inches thick that identifies 1,000 open source applications, some of which have viral licenses. When we actually look, what's happened is that the Black Duck audit has pulled in the development environment as opposed to and development tools, which are never going to be distributed to anyone. And so it is useful to make sure that we're pointing the Black Duck assessment or whoever you're using at the proper application that's actually going to be distributed. One final point about these services, you will note that they have essentially two, but that's a bit of an overstatement, but two ways of using their service. The first is to deploy it and analyze an application or a series of applications on your own systems. Clearly a more secure way of doing it. The other is to request that you upload the source code to their own servers. You can immediately hear, as I say that, the danger in doing so. You're giving somebody access to the source code of something that could be quite proprietary. If you look at the contracts with these sorts of assessment companies, they're not going to assume the level of risk that you're going to want by giving them possession of your source code. So something to please consider. In acquisitions, if you're acquiring a company, making an investment in a company, these sorts of assessments are generally the sort of last stop on due diligence, just to make sure you truly have disclosure of all open source that's comprising a target's assets. Just an example of language that might be used in an end-user license agreement, and mind you, this is the first paragraph of actually two, and so I'll show you the second in just a moment, and you can see them in the slides that we'll distribute. But a vendor might include, that is, a provider of open source in context of a product that they might make available. In other words, you've created a product, a chip, a piece of hardware, whatever, that includes open source along with your proprietary technology. You might include a provision like this, potentially even written more broadly, that addresses how open source is present, referencing a URL where licenses and other information can be obtained. And then on the next slide, you'll see the continuation of this, which is a disclaimer. And why is that disclaimer there? Because we worry about the efficacy of the disclaimers in the open source licenses themselves. Is this permitted under open source licenses? Absolutely, you can do that. You'll note in the middle of this, or right at the top of this particular paragraph, is an optional sentence. A lot of vendors will say, we will assume responsibility for supporting open source in the context of our software, but that we won't take on other responsibility. Let's take just a minute to talk about the trends in the marketplace in this. So right now, the overwhelming majority of product and service providers of all sizes and types, regardless of industry, will generally assume full responsibility for incorporating open source into their own products. So that means that if there's an IP infringement claim, they'll indemnify. It means if it stops working, they will fix it. So the approach shown here in this EULA would be for a lot of products and services that are low dollar value, or situations where the vendor has decided they're just not going to assume that risk other than potentially a support risk. But in general, most providers will assume full responsibility. So let's talk about the sort of three steps, if you will, or three categories of vendors. So first of all, there is the majority, which is full responsibility. If you spend $5 million on a product that includes open source and that open source ceases to function, the vendor assumes responsibility to ensure that $5 million product continues to work. The next step down is one used by IBM and some others, which is to say, look, we're in fact going to disclaim all responsibility for open source. They'll use language similar to what you see here, but what they will say is that if a malfunction in the open source causes our proprietary software not to work, we will in fact assume responsibility for it and fix it. So that is the sort of next category down. And finally, the third category is the we're not responsible, we're disclaiming all liability. And to be clear, there are companies that do just that. In fact, one of the largest information security product vendors on earth, who frequently will have multi-million-dollar, even tens of millions of dollars of deals for products with large organizations like yours, will disclaim all responsibility for open source. And what does that mean? That if you have a $10 million purchase from them and a piece of open source that they, in their sole and absolute discretion, chose to include in their product and it ceases to function, you are out of luck. They will offer no assistance. If you are sued for IP infringement as a result of their decision to include open source in one of their proprietary products, they will offer no protection at all. It's very hard to understand that approach, yet that is sort of the spectrum from full liability to zero liability, even if that means dramatic harm, even if that means that the product being purchased, that is the overall product, is rendered worthless. Let's turn quickly, because that's a nice segue, to consumers, customers of open source software. And that means either you're licensing software directly, where you get open source only, or whether you get open source as part of a commercial product. It can also mean when you're entering into an OEM arrangement where someone's providing open source to you and then you're turning around and making it available to others, or they're providing a component to you, which is a combination of both proprietary software and open source software, and you're going to turn around and make it available to others. Two categories of risk: liability and performance of the products you're purchasing and the threat to your own IP. So let's look at that last bullet point on this page, which is the IP threat is frequently irrelevant. Now what do we mean by that? Well, first of all, we're not talking about an infringement issue. That is, you've spent $3 million for a piece of software, proprietary software, you bring it into your organization and you get sued for IP infringement as a result of open source that the vendor provided to you. We expect that to be indemnified, and generally you should expect your third-party vendors to indemnify you for that. What this is referring to is open source virus issues, those things that we've discussed in detail. If you are not yourselves turning around and redistributing the vendor's software to others, then the threat of the open source virus becomes essentially irrelevant. Consider the average commercial license software that you might get. You license an ERP application. You do not get the source code for that application. In fact, the license agreement for your ERP, Enterprise Resource Planning application, will include a provision that says you can't reverse engineer to get the source code. So you're not allowed to modify it. You're not allowed by contract to distribute it to others. It is remarkable how many times we will see lawyers spend days negotiating the exact composition of open source and the ERP software, specifically focusing on whether or not it's viral. That would be irrelevant. No matter what you do with the software internally, you can't possibly infect any of your own proprietary software. Now, that doesn't mean that the lawyer shouldn't be concerned about overall responsibility for performance of the open source, which is a different matter. But again, all too often, and we just saw this in a negotiation where we were working with a vendor that was providing a overall proprietary product to a customer, and there was open source included in the product, and the vendor, our client, immediately agreed that they would be responsible for the open source and certainly indemnify for any infringement claim. But yes, they use certain viral licenses, and yes, they've isolated them so it doesn't infect their own software. But nonetheless, the licensee had no right to modify, no right to source code, no right to reverse engineer, no right to distribute, yet they were panicked about viral open source included in the product. It would be irrelevant. Other things to think about. Ordinarily, the initial approach is to include a warranty of no open source software. This generally will precipitate a discussion with the vendor that, yes, they do have open source. And then you want to make sure that if the open source is present, will the vendor be responsible for the performance of the open source components? If they're not, how substantial are the open source components to your overall enjoyment of the application? If you're paying $2 million for a piece of software coming into your organization and a nice-to-have add-on is pure open source that you're not comfortable with, then maybe you can live without that add-on, but to understand it a little better. If open source is present, generally we require certain things. First of all, identification of the components. Now, as I mentioned, from the vendor perspective, that composition can change over time. If you are not yourself turning around and including this product in your own product and then distributing to others, do you necessarily care about the composition? No. It's important, and the vendor is obligated under their open source licenses to give you notice of what open source is present and to let you know what licenses apply. And we definitely want to have a warranty that the licensor has the right to distribute it to you and that the open source is going to be treated just like the vendor's own, quote, licensed software. So all the IP indemnity warranties and support will apply. But apart from that, we don't necessarily care what the composition is. In fact, if you have that fourth bullet point covered, you more or less don't care at all what the list of open source is. If you are potentially using the vendor's product in your own product and distributing to others, and the vendor insists on having the ability to change the composition of open source software in its product, you're going to have a contractual out in the event they change from a non-viral to a viral license. And this is an important part to consider. If you are licensing something and you're going to be redistributing it to others, and all of the open source is governed by non-viral licenses, you should understand, though, that licenses change over time and that we have to be careful that a new bug fix includes a version which now includes the GPL license in it. That would be something that we're going to have to deal with. Potentially remove that application or potentially think about terminating the agreement. So contractual out may be necessary. Another point to mention when you are in the vendor's seat and your developers are using open source and they create an open source questionnaire, they fill it out for you and it shows that they're going to be using the open source in a particular way, which is absolutely fine, and you see that the open source license is the non-viral MIT license, you check the box and say approved. Then 3 weeks later, an update comes out for the software, and your developers download it and don't notice that that new update is governed, in fact, by a different open source license, say the GPL v2. So you've gone from non-viral to viral, and it's not been documented. How many times is that missed? Overwhelming majority of instances. We'll get a panic call from a company where a developer has downloaded an update only to find out that the company has switched to a viral license. That should be monitored. In fact, whenever we write an approval for open source, we specifically call out that it is the obligation of the developer each and every time they download a copy of the software as a bug fix or whatever, that they check to make sure the same license applies. And if there is any change whatsoever in the license to a different license, they need to go back and get it reapproved. Last quick point on this. A lot of open source, and this goes back to that whole comment I meant when we were looking at the Black Duck pie chart that I showed you of open source licenses and how the MIT license has grown in use. That is that a lot of open source now is made available under a dual license structure because they know sophisticated businesses are concerned about using GPL governed code. So very frequently we will see software provided as this software, this open source application is provided under a dual licensing mechanism under either the MIT or Apache v2 or GPL. It's normally a non-viral license and a viral license. What should your developers do in that context? Well, there's nothing that they actually tick the box for when they download the application. But what they should do is, as part of their documentation for bringing that open source application into your organization, document that they are electing to have the non-viral license, the MIT or Apache v2 license, apply to their selection. And then they just need to keep watching to make sure that there's never a change. But they need to document that going forward. Just a few other points. Example, an open source warranty that you might include in a contract where you yourself are buying a product which may include open source. And this is quite a simple one, actually. It's just one paragraph, and feel free to look at it when you have a chance to peruse the slides. Next, you'll see a more sophisticated, more fully fleshed out example that is broader. It includes any third-party intellectual property being distributed to you. It includes open source software, and you'll see a specific definition for open source in just a moment on a later slide. You'll see the basic requirements, which are: vendor needs to specifically identify. Vendor needs to attach the applicable copies of the third-party license agreements. Now, frequently we will negotiate this, that if we're not redistributing the software but using it, or the product, but using it entirely in-house, we may exclude out that the vendor doesn't need to attach to the order document the copies of all the license agreements. With regard to open source software, they can provide a URL which can reference the relevant application licenses. But of course, you do want to see any proprietary licenses. Those can impose audit rights and other terms on you that you'd want to have control over. You want to make sure that the vendor warrants they have the right to hand it to you. To the best of their knowledge, they're not aware of any kind of IP problem with it. And unless specifically identified somewhere else in the order, we're not going to have to pay any fees, etc., for the third-party intellectual property, which of course could include open source software. Now let's look at some other components of this warranty. Next slide. You'll note sort of an automatic penalty here, which is that we want to make clear that if, in fact, the vendor fails to identify third-party software in the applicable order, that the default will automatically be it's going to be fully part of the background intellectual property. And certainly with regard to any open source, it will be part of the intellectual property. Now, why are we slicing and dicing a little bit like this to treat sort of proprietary intellectual property differently than open source? You might be getting an application like you could be purchasing some system where an ancillary part of that is to provide you with a copy of Crystal Reports, a standalone application, where the vendor is not going to assume liability for a third party's proprietary software, and Crystal Reports will be separately licensed. Or you might be getting a copy of Adobe whatever, and that will also be separately licensed. So this just allows for that to all work out. There at the bottom, you'll see a pass-through to the extent the vendor is allowed to pass through to the customer any warranties or other protections that the third party provides. Last part of this warranty, there are 3 slides, is the definition of open source software. And you'll see that there is a reference to, in particular in the middle of this, the open source licenses listed on opensource.org, which is a great source of reference and information. It is a non-denominational organization to provide information about open source licenses and open source licensing in general. It will list licenses which actually satisfy the requirements to be an open source license. You'll be surprised at how many are actually there. It is quite a few. You'll also note sort of a backup, which is, suppose it's not something that would be traditionally called open source, but satisfies the requirements in Romanet 2, which is something that would require relicensing any proprietary software that comes in contact with it under some sort of a license that requires disclosure of source code, that sort of thing. So it's just a fail-safe. So there's a general definition of open source provided there. Lastly, pulling it all together. Understand the real risks, and I suggest those risks are manageable. They're those that we discussed, primarily viral, primarily understanding the remedies that, or lack thereof, that are available to you as a licensee of open source, but also understanding how you can blunt the impact of those things. Understanding what perspective you're contracting from, whether you're a consumer or distributor of technology that involves open source. Documenting how you're using open source within the organization, and generally that is by virtue of using some form of questionnaire that the developers fill out. Control and risk, mitigate risk of use, and that is done by contract and also by examining how open source is being used. Let's just linger there for one moment. One of the questions that comes up all the time when we have these presentations is we've got a product that we're going to ship out to customers, and we absolutely positively need and cannot find an alternative to a piece of GPL governed software? Are we sunk? The answer is it depends entirely on how that piece of open source is being used. Are we dynamically linking to it? Have we modified it? If we have, we've certainly lost, and if we distribute those modifications, no question. And normally most clients are comfortable with that. The real question is, what about if we combine it, can they reach our proprietary software which is underlying? And again, have we linked it statically? Then likely we're going to lose control of our proprietary intellectual property. Are we dynamically linking it? Excellent. Are we distributing it on media or a download file where these things are kept separate and then dynamically combined on execution? These are all the questions that we would need to ask to understand whether or not we've created a true problem or not. Lastly, if someone's furnishing open source to you, holding that person accountable, whether that open source is standalone or whether that open source is combined in some form of a commercial product or not. Just moving to our 5-digit CLE code, and let me give that to you now, and you must enter it on your screens. Please make sure to do so, and I'm going to linger on this screen to help you do that. The code is, in all capitals, Y as in yellow, G as in good, Y as in yellow, S as in Stephen, and T as in Tom. So please take a moment and enter that into your screen. Now, hopefully everyone has that entered. Let me give you that code one more time. It's YGYST. Now, right now, I show no questions pending, but please let me invite you to email me after this. If something I said becomes completely confusing or makes no sense, shoot me an email and I'll be happy to respond. Also, I mentioned a number of tools and forms and templates during the course of the presentation. If you should like any of those as an example, again, shoot me an email and I would be very happy to send them. Or it may be that one of you wants to just send me a list of things that are of interest to you, and I'd be pleased to respond, and that person can then distribute. But happy to do any of those sorts of things. Well, it has been a pleasure talking with you, and thank you so much for your kind attention and time today. And again, do not hesitate to reach out with any questions. And with that, I believe we are through, and so I'll wish you a good rest of the day. Thank you.